The Supreme Court has termed as very unusual and not a very happy situation the allegations that West Bengal Chief Minister Mamata Banerjee entered the premises of political consultancy firm I-PAC while the Enforcement Directorate was conducting a probe on January 8 and allegedly obstructed officials from performing their duties. The apex court observed that such incidents reflect an undesirable confrontation between state authorities and central agencies, stressing the need for a clear remedy to prevent similar clashes in the future. The remarks came as the court examined the broader implications of the standoff, highlighting concerns over institutional conflict and the smooth functioning of investigative processes. A bench of Justices Prashant, Kumar, Mishra and N.V. Anjaria observed that the Supreme Court may have to step in to determine the course of action in such situations, while expressing concern that similar incidents could arise in other states as well. Referring to the allegations, the bench noted that if a chief minister is accused of barging into premises during an ongoing probe, and if remedies under Article 226 and Article 32 are held to be not maintainable, it raises a serious question on who would adjudicate such disputes. Calling it not a very happy situation, the court underscored the need for legal clarity to address institutional conflicts. The Supreme Court observed that the situation raises serious constitutional concerns, noting that if a chief minister is alleged to have barged into an office during an ongoing probe and remedies under Article 226 and Article 32 are deemed not maintainable, it creates a troubling legal vacuum. Calling the episode unusual and unprecedented, the bench warned that similar incidents could occur in other states in the future. The court stressed that there cannot be a vacuum in law and that a clear remedy must exist to address such conflicts, underscoring the urgent need for a mechanism to resolve disputes between state authorities and central agencies. West Bengal Chief Minister Mamata Banerjee and the state government have challenged the maintainability of a plea filed by the Enforcement Directorate and its officers in the Supreme Court, arguing that central agencies cannot claim a fundamental right to investigate cases. The state told the apex court that allowing such petitions where agencies seek the status of a juristic entity would undermine India's federal structure, opening the door for government bodies to litigate against each other. Appearing before a bench of Justices Prashant, Kumar, Mishra and N.V. Anjaria, the state further argued that agencies like the ED, CDI, CID and SFIO are neither natural nor legal persons entitled to invoke writ jurisdiction under Article 32, nor can they sue a state government. Senior advocates Shyam Diwan and Kapil Sibal, representing the West Bengal government and Chief Minister Mamata Banerjee, told the Supreme Court that the Enforcement Directorate is merely a government department and cannot be treated as a separate legal entity with fundamental rights. They argued that permitting such a plea would set a dangerous precedent, effectively allowing one government department or even one government to initiate legal action against another over alleged violations of fundamental rights. This, they cautioned, would blur constitutional boundaries and weaken the federal structure by opening the floodgates to intergovernment litigation. Senior advocates Shyam Diwan and Kapil Sibal urged the Supreme Court to refer the matter to a larger 5-judge constitution bench, arguing that the issue carries far-reaching implications for India's federal structure, one of the basic features of the Constitution. They cautioned that allowing such pleas could blur the line between the centre and states, effectively pushing India towards a unitary system. India cannot be turned into a non-federal country, the Council stressed, warning that permitting government agencies to invoke writ jurisdiction against states would open the floodgates for intergovernment litigation. Kapil Sibal strongly argued that no agency or officer can claim a fundamental right to conduct investigations, stating that such powers are purely statutory in nature. I do not know how fundamental rights come into the picture, he told the bench, adding that any remedy lies within the Bharatiya Nyaya Sanhita and not through a writ petition. Echoing the argument, Shyam Diwan said the Enforcement Directorate is merely a government department and cannot be treated as an independent legal person capable of invoking constitutional remedies. Senior advocates argued before the Supreme Court that the Enforcement Directorate has no independent legal personality and therefore cannot maintain a petition under Article 32. They warned that if such pleas are entertained, it could set a dangerous precedent where one government department sues another, or even the centre and states drag each other to court over alleged violations of fundamental rights. Such a situation, they said, would bypass the constitutional checks and balances and disrupt the federal framework. The apex court was hearing petitions filed by the ED and its officers seeking a CBI inquiry against the West Bengal government, Chief Minister Mamata Banerjee, the then Kolkata Police Commissioner, and other officials. The agency alleged that its officers were obstructed while carrying out searches on January 8 at multiple locations in Kolkata, including the office of political consultancy firm I-PAC, while the Enforcement Directorate was conducting a probe on January 8 and allegedly obstructed officials from performing their duties.